Officially call the first case on this evening's docket. It is case number 116690, State of Kansas v. Lee Edward Williams.
May it please the court, Peter Meharry for Lee Williams. If I could have 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes before the court after Mr. Williams' conviction for first-degree premeditated murder. He was also convicted of a separate charge of criminal possession of a firearm. His sentence was life imprisonment without the possibility of parole for 25 years. Followed by a sentence of 20 months for the criminal possession charge. The facts of this case and the charges of this case arose out of an incident on September 4th, 2013. Ultimately, the victim in this case was shot and died from those wounds. How that came about was the subject of disputed testimony. The state's allegations and witnesses testified that my client, Mr. Williams, and the victim had an on and off relationship over the years. They also had a child together. And in the early morning hours of September 4th, they got into an argument. The testimony from two witnesses, one being the grandmother of the victim and the other being an aunt of the victim. They both testified they heard a commotion in the house. They came down to see my client trying to drag the victim out of the house. They both intervened, and at that point, my client proceeded to shoot the victim. My client testified that he was at the house, and there was an altercation between them. However, his testimony was that they got into an argument. He proceeded to grab their child and was going to leave the residence when the victim pulled a gun on him. He set down his child, and then the two struggled over the gun. During that struggle, the firearm went off, resulting in her death. From that, we have raised three issues in our brief. What I'd like to do is go through the first two, and then time permitting, maybe touch on the third. The first issue deals with our allegation that the prosecution improperly, in closing arguments, called my client, Mr. Williams, a liar. As this court has said over the years, it is improper for the state to call the defendant a liar in closing arguments. This goes back to Pabst, where this court has said that that is a comment on the credibility of the witness, and that is improper for the state. Credibility is solely left to the jury, and neither side can comment on the credibility of witnesses. In this case, particularly, the comments we have problems with are when the prosecutor argued to the jury that my client made up his story as he was testifying, and further that his story was false and a fabrication. We believe that when you look at this court's prior cases such as Elnicki and Brown, which we've cited in our brief, this court has said such comments are improper as they amount, while they don't use the term liar, they're one and the same. And again, that is a comment on the credibility of the witness such that it is improper for the state to do.
But haven't we also asked, or in our review, looked at the context of those statements? And here, before those statements were made, the prosecutor told the jury it would be their duty to decide the credibility of the witnesses, told them that you heard two divergent views, and then said, I'm going to tell you the reason the evidence stacks up so that you should not believe the defendant's version. Isn't that different than calling the person a liar?
I think if the state would have done that, I would argue that that's arguing the evidence, but I don't think that's what the state did. The state did go through the evidence and say this is what the evidence shows, but then the state went the next step and says, I'm going to suggest to you that the defendant made a lot of his story up. That's not a comment on the evidence, that's a comment on my client's credibility. when the state says, I'm going through this evidence, and then says, which I suggest to you shows that this version is false, his version is a fabrication. It's that next step that I think we run into the problem. We don't have a problem with the state saying, this is what the doctor testified to, or this is what the witness has testified to. That's not consistent with what the defendant has testified to. It's that next step where the state then goes and says, I'm suggesting to you, the jury, that's a fabrication. And I think when the state makes that type of comment, it is a comment on the credibility of my client. It is putting the backing of the state behind that and arguing to the jury, look, we know, we're the state, he's lying to you. And this court has said from Pabst through multiple cases, the state can't do that. And that's where we have a problem with the comments from the state in this case. It's just that extra step where the state goes on to say, look, it's a fabrication.
So
His
it's the
story
use-
is made up.
Counsel, it's the use of the word fabrication or made it up, made a lot of the story up. That's the part you're objecting to, or is it the I suggest part, or is it both?
I think it's the whole sentence. I suggest to you that this is a fabrication. I suggest to you he's making his story up.
And in your view, the law is that even if both of those statements are swimming in a recitation of the evidence and the ways in which the evidence contradicts his story, that once those words are uttered, we have error.
I believe that that is improper. That is commenting on the credibility of the witness in this case, and that is what this court has said the state can't do.
But we've said the court that the prosecutor can point out where there's conflicting stories or conflicting versions, that the prosecutor can point out why the jury should believe one over the other, and that's what he was doing here. And he says that's what we're getting at. You're going to have to go in there and say, am I believing Ernestine and Laura, or am I believing what the defendant had to say? That's the sentence that preface what I'm going to suggest. And then he says, I'm going to suggest that he made the story up as he testified on the stand, asking that, hey, you saw this guy, and here's the two conflicting stories, and here's all the evidence, and here's why you should believe my version. And we've said that's okay, haven't we?
Yeah, and I don't have a problem with the state getting up there and arguing all the evidence. I point to my two witnesses, the aunt and the grandmother, medical evidence. I don't have a problem with the state saying that shows that this was a premeditated killing. It's when the state then says, I'm going to suggest to you he's making this up.
Didn't the
That's
state-
not a
didn't- Didn't the state actually say, I'm going to suggest to you that this shows, and isn't the this shows an important part of the sentence that you're sort of eliding?
What I'm looking at, Your Honor, is volume 17, page 586, and it
Is that
says,
the defendant made up a lot of the story?
I'm going to suggest to you that the defendant
Yeah.
made up a lot of his story
And
as
there's-
he testified on the stand.
There's no, that this shows, that doesn't show up in that sentence, but the later portion of the transcript that you complain about, where the prosecutor uses the words, his version is false, his version is fabricated, is preceded by, I suggest to you that this shows, he's talking about the physical evidence, that his version is false. Does that make a difference in your view?
I don't think so, because I think you still have the prosecutor saying, I suggest to you this is fabricated.
Can the prosecutor say, I suggest to you that the evidence shows?
I think the prosecutor can say, I suggest to you the evidence shows this was a premeditated murder. But I don't think he can go beyond that and start commenting on the credibility of my client's testimony. I think that's where, from my reading of the case law, is where the line has been drawn, is that you can't make that comment because that is left for the jury.
And speaking of case law, what is the strongest case that you rely upon for your position?
I would point the court back to both Ilnicki and Brown. I believe that both of those cases use similar language, and in both of those cases, this court said that that was improper, where the state was commenting on the credibility of the witness, and that goes beyond what they can do in closing arguments.
Let me move you over to the other issues while you still have some time. On the jury selection issue, you had 3 jurors who were African-American that were struck by the state through peremptory challenges. One of those is juror number 29. As I read I want to just confirm this, as I read your brief, you don't have a problem with that. That was a race-neutral reason when the state said they struck him because he was unemployed, right?
That is correct, Your Honor.
Okay, so we're only focusing on jurors 12 and 13.
Yes.
Okay. And then on the photographs, I had a little problem with, there are 5 photographs involved. You don't really challenge the 2 photographs on the second shot. You know the ones I'm talking about. They're just kind of, I mean, they're bullet holes in the body, but it's not.
The focus.
I mean, the other 3 are more stimulating.
That's correct, Your Honor. Yeah, the focus would be on the other ones, particularly the ones that's showing the facial wound and the one with the rod showing trajectory.
So focusing on the 3, which is a bullet wound to the face, to the left eye, I think it is. Let's assume it's error. Make the case that it would be reversible, that it's not harmless.
I think in this case, the problem we have with admitting those is it does play on the sympathy of the jury. It creates sympathy for the victim in this case, and it's particularly harmful because the jury sees that during the case state in chief before my client gets on the stand. And I think he already kind of has one strike against him once he gets on the stand. In this case, his testimony was that this was not premeditated first-degree murder. It was self-defense, or at least a lesser degree. So it's vital for him when he gets on the stand that he gets a clean slate from the jury, that they will take him and view his testimony without any prior biases against him. And I think when they put in those pictures, that does create that inherent bias, inherent favor for the victim in this case, and to push the jury to convict because of what she suffered. And that way his defense is undercut because he's not really given that fair shake when he gets up and testifies in front of the jury.
Could we back up to the race-neutral explanation given for the peremptory challenges on the jurors number 12 and 13? What is your particular issue with how that played out? One was talking about a profession that the prosecutor didn't particularly want that person with that employment on the jury. Why isn't that race neutral?
I think, it probably is race neutral. The problem I have with what the prosecutors stated for their reasons for striking these jurors is they essentially don't make any sense. I think they show a pretext more than anything. Pretext that we're going to strike these people. We can't say it's for race, so we got to come up with some reason.
What do you base the pretext on when you say it is a race neutral reason, but it's a pretext? Why how can we conclude that?
I think this court can look at the reasons stated for striking these jurors and say these make no logical sense. They don't make any legal sense. And that can be seen as a mask for the real reason that they were struck. I certainly understand the standards involved in Batson, and I understand, the odds are high. But I think this court can look at what the prosecutor stated as for the reason for striking these jurors and ask itself, does that make any sense? With juror 12, it was what the prosecutor didn't know if it was a male or female. What does that matter? Why do we care? That doesn't exclude anybody from being on a jury.
It's interesting the distinction that we draw between a non-minority peremptory challenge, which can basically be for anything, but then when you have to articulate a reason, what creates the difference in exercising the peremptory?
Well, I think that what creates a difference is Batson versus Kentucky, and the finding that striking minority jurors violates the Equal Protection Clause of the Constitution. And certainly, this court, I'm sure, is well aware of the history behind striking minorities from jurors. It has been a problem over the years, and Batson versus Kentucky, they found that that was
But if the
violating.
reason is I don't like this person who's engaged in this particular profession, and that suffices for a non-minority peremptory, because you don't have to state what the reason is. Why, and it's a race-neutral reason, why doesn't that suffice then for this?
Because I think when you look at the rest of the jury panels, there were others that were similarly situated than this person, but were not struck.
Were any of those arguments made below about the people who were similar in these respects, the reasons given by the prosecution?
It wasn't articulated, Your Honor, you know, and I
So
recognize
that's one
that
problem for you.
there is a problem with the record made below.
Right. And then, because it is your burden on step 3 in Batson to demonstrate pretext, or
Under Batson, the burden is placed on the defendant to show that there
or
was.
if not pretext, that they're not believable in
Right.
some way. And we just can't judge credibility up here the way that a trial court can.
Arguably, I don't know if I necessarily agree with that. I understand this court has said that, and that is this court's case law.
Do you think something about that deviates from Batson?
I don't think there's any case law that I can cite to that would say it does. But I would argue to this court can look at the reasons given. This court can look at Boyd Dyer and look at who was picked and who was not picked. And I think this court can come up with its own conclusions as to what was the basis for those picks.
In this
And now-
particular case, did you end up with any minority jurors, any African-American jurors?
The makeup of the jury, I know there are minorities, there are both Hispanic, African-American, and I believe one Asian,
Who actually served?
who actually served, yes, Your Honor.
Okay, thank
And
you.
to continue on the vein that Justice Breyer was talking about your burden and standards of review, once the trial judge has made his or her decision that this does not meet the Batson challenge, we review that decision under an abuse of discretion standard, correct?
That is correct, Your Honor.
And what particular type of discretion are you arguing was abused by this trial judge?
I think for one thing, and if you look at the Boyd Dyer in this case, I don't know that the district court ever actually got to the third step. If you look at what the district court said, it basically said, after the state said, these are the reasons why I'm striking these jurors, the district court said, those are race neutral, so I'm going to deny your Batson challenge.
So in other words, of the 3 types of abuse of discretion, you're saying that the district judge applied the wrong legal standard?
Yes, Your Honor. I don't think the district court made that determination on the credibility of the stated reasons. It just basically said, and this is volume 18, if you look at what the district court says, and this is page 133, they are all race-neutral explanations, and I will deny the Batson challenge on number 12. For number 13, he said, certainly striking for age is a race-neutral explanation, so I'll deny your Batson challenge. I don't think the court ever made any credibility determination on that. You know, it just seemed to say, I got a race-neutral reason, and that's enough. And I don't think necessarily under Batson that is.
Counsel, you're well out of time. Do you need about 15 seconds to wrap up, or we'll just wait to see you on rebuttal?
Rebuttal is fine, Your Honor.
Very well, thank you.
Thank you.
If it please the court, the state of Kansas appears by and through Lois Moline, Assistant District Attorney. The facts as set forth by my colleague here were appropriate. I do think there are additional facts that might be important to look at, especially if there was any kind of analysis of harmless error here. And I think part of it goes towards the first issue, which is that, that the prosecutor, during his closing arguments, made statements basically alleging that he made statements calling the defendant a liar. We would argue that, in fact, That's not what he said at all. I mean, yes, he did say fabrication. He used that word. He used other words, but in the context they were stated, the intent here of the prosecutor, if you look at the context and the whole sentences, he wasn't calling him a liar. For example, in the statement that's been complained of, where the prosecutor said, "I'm going to suggest to you that the defendant made a lot of his story up as he testified on the stand," the rest of the same sentence was, or while he was on the stand, "and I'm going to get to that in this way." In other words, the prosecutor made a statement and then told the jury, and how I get to my suggestion is, and at which point he then started laying out the actual facts and how they didn't match the defendant's statement.
Is there a difference between saying he made the story up or he's lying, and I'm going to tell you why? Is there a difference between those two?
I think if the only thing the prosecutor says is you heard the defendant and he's a liar or he's lying,
And then
as opposed to explaining why you want to suggest that this is, he fabricated it, and pointing out actual evidence that was admitted during the trial, I do think there's a difference. Yes.
Is it the characterization of the lie, of calling someone a liar versus someone who's not being truthful? Is that kind of the distinction here?
I don't think so, no. I think it's the way it's approached and how it's explained. In other words, the entire sentence or the entire paragraph instead of the phrase that uses fabrication or whatever whatever word is used. And in this case, I think that the prosecutor started out at the beginning saying, you know, you have two different versions, jury, and it's your job to decide which version, and you can look at the facts to do that, and I'm going to suggest that the defendant's version is fabricated based on fact. And then he closes that up a couple pages later, after lots of talking, so that I suggest to you that the version given by Laura and Grandma, which I'm sorry are the aunt and the grandma, and he goes on to suggest that that's the one you should believe because again, how the facts match these two different statements. If the court were to find that one or more of these statements were error, in other words, he went too far in using the word fabrication or something along that line, I would argue that the court could also find in this case that it's harmless error. He wasn't flat out calling the defendant a liar. He was definitely addressing these statements to the facts that were adduced and asking the jury to find whether or not the defendant had told the truth when he talked about this, for them to compare the facts to his statements, but also that the evidence against him was overwhelming. 2 eyewitnesses testified about what they saw. They heard lots of physical evidence, which went along with their statements, whereas the physical evidence didn't match up his statement of how this shooting actually occurred. Of course, there are other facts that go along with it too, like he took the gun with him. He claimed he lost the gun. He then immediately left for Canada within a matter of a very short time. All of this evidence goes towards his guilt, and I would argue that even if the prosecutor had overstepped his bounds, that in fact it would be harmless error.
Would that be true even if we pile on error because of the word fabricate, you know, his version is fabricated.
Right.
Now, it's hard for me to separate out his version is fabricated from the Brown case, which I also think was out of Wyandotte County, if I remember. I think that's one of mine, but where the prosecutor from your office said that the defendant had the weekend to come up with a story. The phrase was "come up with a story." I'm having a hard time making a distinction between coming up with a story and his version is fabricated. But take that one and then add on to the arguments the defendant's making about the prosecutor using his credibility.
Right.
With some of these other statements that are in the closing. The one I focus on is right up above that in the transcript where he talks about I suggest the defendant testified to you, and to be honest about that, that was quite a quite confusing version of the facts. Now, that's not calling somebody a liar. That, to me, that's saying, I think that's a confusing thing. And so it seems to me we have the prosecutor moving over into the area of calling the guy a liar, and on other aspects of the case, putting his personal credibility, the credibility of the state, if you will. And if we pile that on to this, do we get any closer to reversibility?
I don't believe so. I do think that saying "I suggest" is probably not the best way to say the exact same thing in another way, because there is that indication that it's trying to use his personal opinion here. I would say, as to the confusion, that was quite a confusing version of the facts. That again, that's part of a sentence, because he says the whole sentence is that was quite a confusing version of facts that he gave, when he could say, I don't even know how the gun was fired and who fired it. The cross-examination of the defendant, when he has described this event and how the shooting happened, there was lots of questions, well, how did this happen and how did that happen? And the defendant wasn't able to answer those questions, and he claimed he didn't know how the gun was going off, and he didn't know how the shots hit the victim, and his version and the actual physical evidence didn't match up, but he couldn't explain any of that. I think that the jury would have heard this not that very long before these closing arguments, would have seen that testimony, and and maybe saying his own version of that, saying it in such a way that it indicated it was his belief, but but in fact, he points out specifically, this is what you just heard, and that is a confusing version of the facts.
Here's what I guess I'm reducing this to. What other evidence did you have besides the conflicting testimony where the jury was going to have to decide the case on credibility? I mean, it seems to me they either believe the aunt and the grandmother, or they believe him because it's about a struggle and all that. I mean, what other evidence did you have that would indicate guilt besides deciding the credibility?
Okay, well, I would say he admitted, he put himself there, he put himself with his hand on that gun. When it was firing, he took the gun with him and said he had lost it on the walk home, and then he immediately fled to Canada, and was caught as he was crossing the border. All of those are completely outside the statements made by the aunt and the grandma, which also do point to his guilt. That the physical evidence of the way that these two wounds occurred, and the part of her body that was hit, and the angles and stuff. For example, supposedly she got shot in the forehead, going downwards into her face, down into her chest, but it was from 2 to 3 feet away, so it would be pretty hard for her to have done that herself, which is one of the things the defendant tried to imply by his description of how the events happened. So the physical evidence of the 2 gunshot wounds doesn't match his version at all, and match as much as they are. The two older women basically were saying he was shooting at her lots of times, so they don't say a lot of details.
He also said she sat up too, didn't he?
Excuse me?
He also said she sat up before he left.
That is right. I would agree with you, Justice. He said in his statement that the last thing he saw before he left the house after the shooting was the victim was sitting there, and he didn't even know she'd been shot. But the evidence was, and the photographs you all have seen include the fact that she was shot in the face, which went in one place in her face and came out in another place in her face, and would have most likely had quite a bit of blood. And he claimed he saw her sitting there, and he didn't even know she'd been shot. He found that out. He found that out some other day by a third party, but he'd already fled to Canada prior to that. So all of those things also point to his guilt in this matter, I would argue.
I can't remember. I have an impression, but I can't pull it out. Did you guys establish that the entry wound into the left, over by the left eye, was the first shot? I can't remember the order of the bullets.
I don't think there was any way for the doctor to detail that. The second shot into the back definitely was the kill shot, because that entered the heart. The first one wouldn't necessarily have killed her, and it's possible that it caused her body to, she might have been moving, and then, because she ended up on her front before the EMTs turned her over. She was face down, and the second shot did enter her back, so it could easily have entered after she rolled over. But the doctor wasn't really asked that very specific question. As,
Counsel?
sure.
I was going to follow up on that, but if you're moving to another area, go
was
ahead.
gonna move
That's
to an
fine.
issue. Do you have
I was just going to address, this doubles back to what Justice Stiegel was talking about in the closing argument. The paragraph, the shot could not have been fired by Taisha.
Taisha, yeah.
She's not going to be able to shoot herself coming from behind in the manner in which the doctor testified. It just can't physically happen.
Right.
So this is going to what you were talking about.
Yes,
shots.
yes, but based on the stippling, which was a very important fact, the doctor opined that the gun had to have been 2 to 3 feet away, close enough to leave a little bit of stippling, but not near close enough to be like up against her head. And if anyone were to try, such as a juror, to figure out how she managed to shoot herself from above 2 or 3 feet away into her own face, it doesn't seem to be rational. And so at least that's the argument, that this doesn't match his version of events at all, so.
Which the prosecutor said, I suggest to you that shows his version is false, his version is fabricated.
Right, and that's what he was pointing out, yes.
Counsel, I wanted to talk about Batson.
Sure, yes.
Maybe what its limits are, what protection, if any, it actually offers. And that's, you're kind of smiling because I know you're understanding where I'm going here. I think the phrase is race-neutral reason, right?
Right.
So if we could move for a moment from the race-neutral and talk about a reason. And it just seems to me that some of the reasons, we'll use that word temporarily, that the prosecution gave here just have nothing to do with jury service, period. And so does Batson mean anything more than race neutrality? Does it mean they have to be sensible or logical, as your opponent suggests, or is that just not part of it?
Well, I wouldn't disagree that logical makes sense, and I would actually agree that a couple of these reasons don't make a lot of sense. But in fact, the prosecutor in this case gave more than one reason for both Juror 12 and Juror 13. The judge basically focused on one in each and found race neutral.
13, I think, to me, they sound like the same thing, stated two different ways. Being only 19 and not having life experience sound like the same thing to me.
Oh, and also that this is one of the jurors that wasn't married. That was another thing. Now, the judge never addressed that one, but that was actually that was also said within like the same sentence or the next sentence.
Okay.
So the prosecutor had given a number of reasons for that second juror.
Okay.
I would say that being very young and not having any life experience is a rational reason why you might not want a particular juror on the stand.
That one sounds a little more reasonable to me
Yes.
than the prosecutor isn't quite certain what gender someone is.
I
I can't
know.
figure
that
that
one
out.
actually didn't make a lot of sense to me either. But it was
Yeah.
But you know, when you're put on the spot, and I've been there, where the basically the judge turns to you and you're looking at all your notes, trying to remember what all you wrote down, and possibly you just start saying all these reasons you have in front of you, and maybe at that moment that one doesn't make a lot of sense. But the other reasons, I mean,
And
why
why
I
should-
think a particular
Counselor?
profession isn't a good profession. Go ahead.
Counselor, if you have an African-American defendant,
Yes.
and you have African-Americans on the veneer panel,
Right.
why wouldn't you be prepared to back up your peremptory strikes of the same minority, knowing Batson's been there for decades? And so I don't know
I
why
think-
it should be a spur-of-the-moment thing for the prosecutor. You know this is out there.
True, and some of that stuff you get from the jury questionnaire, some of the information. So maybe you had a few moments to look at that ahead of time. In Bryant County, we don't get our jury questionnaires. We get them for about 20 minutes right before voir dire. So it's no time
but
to
the
hardly
point-
read 50
The
jury
point is
questionnaires.
Justice Johnson just pointed out, you're exercising at the end of jury selection, your
Right.
peremptory challenges.
Right.
And if you notice that this
I agree.
relationship, shouldn't you be ready to explain to the court why why you're excusing this particular jury that fits into the Batson paradigm? I mean, what's so hard about that?
I think that in both
And so
cases,
I don't
they
recognize
listed reasons why they.
I don't recognize, I didn't recognize the person's gender is,
I don't know why he said that.
well, that's the point.
But juror
But
12,
then
this
he
is juror
added
12.
two other things too. He didn't just say that.
Yeah, that saw perhaps the juror nodding off, which no one else saw.
Well, what the judge said is, I didn't see them sleeping, but in fact, a person can nod for a second,
And
and maybe people didn't see
I
them
guess
sleeping. I
that's-
wouldn't argue that those are the exact same phrases.
That was my point, though, that I made to counsel for Mr. Williams, is that it's more than just exercising a peremptory challenge for a non-minority juror.
Right.
You can just kind of do that. You don't have to
Right.
give any explanation. Here you do. And I'm just struck by the explanations being so, it just didn't seem to fit with the purpose of Batson or the purpose of, or the function of a juror. It just,
Well-
it seemed to be missing.
So if you were, if a prosecutor is questioning a juror and notices their head nod a couple times, I would note that. That would absolutely be some reason I might not want that juror. And because the judge doesn't ever actually see them sleeping as opposed to nodding off, I don't know that that means that the prosecutor was lying. It means that that's something they observed. And it's a very legitimate reason why you wouldn't want somebody on the jury, I think, that they weren't paying attention. Jury rooms are always hot, and they're always crowded full of people when we're doing voir dire, and I had a juror, we realized as we took a break, that there was a juror sleeping on the, and nobody had even noticed it, and we don't know how long he'd been sleeping, so he ended up not being on the
Counsel?
jury.
Assume for a minute that we agree with you.
Okay.
That whatever reasons were given are race neutral and
Right.
they're actual reasons. Does that end the inquiry?
No, because the next step that's required is the third step,
Right.
because the
and
defendant
you-
has the burden then.
The defendant is suggesting
Right.
that he never had the opportunity to prove up his allegation of of a race-based strike.
And when he said that here just a few moments ago, I looked at that because that struck me as that I didn't remember that at all. The state, and I'm here in volume 18, and this all starts on page 131, but then if you go to page 132, the state has, in the middle of that page, the state has listed out his 3 reasons, including the one about the gender. He lists out his 3 reasons. The judge then turned to the defense attorney, whose name is actually Klein Boone, and it says, Klein, at which point Mr. Boone then talks about things, and he's had an opportunity to say what he needs to say. So the judge did ask for a response, and the same on juror 13, which that comes up at the bottom of 133. Mr. Gorman, the prosecutor, had again stated his reasons, at which point Mr. Boone then talked for the next couple paragraphs. So
but
it's not
can't
that the judge,
Can't the defendant or defense counsel challenge the race neutrality of the reasons?
sure.
And that's still the second step, though. That's still the second step. The third step is all the race neutrality does is shifts the burden from you back to the defense. That's all it does. And then the defense has the obligation to show that you're engaging in a pattern of discrimination based on race.
Right.
Okay? So while you're arguing whether you have met the burden or the level to shift the burden back to the defense, you're not simultaneously discussing the third step, are you?
If I may, step 2, according to State v. Kettler, 299 Can 448, I cited in my brief, it's one of the many cases that cites the 3 steps and goes into detail on them. And it talks about the second case, the second step. It says, and I quote, the reason given, must be facially valid, but it does not need to be persuasive or plausible I find that an interesting case under this discussion we're having. The reason offered will be deemed race neutral unless a discriminatory intent is inherent in the explanation. The opponent of the strike continues to bear the burden of persuasion, at which point it goes to the third step, and where the court has to make a decision. But there's lots of case law saying that the defense has
Decision
a
about
burden
what?
then to whether or not it's race neutral, whether or not it,
No, the third step, the decision is whether the state has engaged in
Oh,
a
true.
pattern of discriminatory
Right.
practice by striking
Right.
the minorities. And you're already past the race neutral finding. And what we're getting at is, did the judge here ever finish off the analysis by saying they were not only race neutral reasons, but I'm convinced that the prosecutor was not engaging in discriminatory strikes. And that
I don't
that
think the
doesn't
judge said
appear-
that phrase,
Excuse me,
no.
Counselor,
I
that
apologize.
holding doesn't appear in the record, does it?
I would agree with you that the judge didn't make that specific
Okay.
comment, no. I would also say that I read a lot of case law when I was writing this, and I don't remember ever reading where they quote a judge saying something along that line. And I don't remember ever having a judge in front of me who's actually said those words, but I'm just letting you know.
Counsel, you're well out of time. Would you like 30 seconds to wrap up?
Just 30 seconds, Your Honors. I would just argue that in issue 1, the prosecution did not err in its statements. I do not believe it went over the line, but if you were to find that it was wrong, that I would argue that harmless error would save that particular issue. I do not believe that there was any violation by the prosecution in their strikes against African Americans. In this particular case, 3 African Americans, an Asian person, and 3 Hispanic people were all still left on the jury. I believe there were only 4 white people left at the time. I'm sorry, white jurors left at the time that the final jury, when this Batson issue came up. I don't think there was a pattern at all of the prosecution violating the Batson rules. And as for the photographs, I would just argue that the court analyzed this, and I do not. And these photographs about the angles and the stippling were very important to the state's case and it turned out because of the defendant's statements, they became highly important. And the fact that they might have been somewhat gruesome in no way means that they should have been kept out. That they were very important in the state's case. There.
Thank you, counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
May it please the
Can
court.
you address counsel's last point about on the Batson challenges? That you're arguing there was a pretext here to excuse minority jurors when the majority of the jury appears to be made up minorities. How does that factor into your argument that there was pretextual peremptory challenges here?
Your Honor, I don't think it changes my argument. I think that what the courts have said is that striking any juror based upon race is unconstitutional. The fact that you might have some minority jurors left on the jury panel doesn't change that it's improper and unconstitutional for the state to strike other minority jurors from that jury panel.
Can we use that fact to substitute for the judge's perhaps lack of clarity on the third step and draw a conclusion on our own that there was not a pattern because there were many minorities left?
I don't think you can. I think the fact that there were minority jurors on the panel doesn't necessarily, I guess, gloss over the fact that they used pretextual reasons to strike other minority jurors, and I don't think that fact can be.
We don't know that they were pretextual. That's what we're struggling with. And isn't the fact that there were other minorities still on the jury at least some evidence that the reasons weren't pretextual? I think that's the tenor of the question.
And I would argue no, because I think you can find that these strikes were pretextual based upon the reasons given by the state.
You look at it in the micro, we don't get to look at it in the macro.
No, and I don't think this court has ever said, we work on a quota system or anything like that. You look at the individual strikes and see if those have any basis, if there's a race-neutral reason given, if those are pretextual or not.
Can
So if you
Batson
had-
ever be harmless? Can a Batson error ever be harmless, under your view?
I don't believe it can, Your Honor, 'cause I
So,
think,
I'm sorry, I didn't mean to cut you
I'm
off.
done.
I cut off your answer, I thought.
I was just going to say, once you improperly strike one juror based on race, I think you undercut and violate the Constitution such that the panel cannot be saved.
And just so I'm clear, to extend that out, if you struck panel members because of their race, African-American, and you wound up with 12 African-Americans on the jury, what's your position on that? Is that a problem?
I still think it's a problem, and I think when you look at Batson, it's looking at why you strike jury members. It's not looking at what's left. It's looking at who you struck and why did you strike those members. And if you are striking them based upon race, what this court, what the U.S. Supreme Court has said is that is unconstitutional and cannot be allowed. So I don't think you look at the ultimate jury. I think you look at the strikes that were taken and questioned at trial. I don't have anything further unless there are other questions from the court. I would just ask that this court reverse and remand this matter for a new trial for the reasons stated in our brief.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this evening. Court will take this matter under advisement.